Are you satisfied and happy with your attorney?
Yes.
Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Mr. Starkey, are you admitting here today that you in fact did batter or injure a law enforcement officer?
That's what I've heard.
And you didn't have consent to do so?
No.
And are you admitting here today that you in fact did throw or expel urine?
Hold up, did he just throw bodily fluids at jail staff? Yeah, that's not just nasty, it's a felony. And in Wisconsin, that charge carries serious prison time. This isn't just jailhouse mischief, folks. This is dangerous and calculated.
Deputy?
Yes.
And you didn't have consent to do so?
No, I did not.
All right. Do you have any questions for the court or for your attorney before I proceed?
I do not.
Okay. Mr. Keene, did you go over the facts alleged in the criminal complaint with Mr. Starkey?
Yes, Your Honor. Went through all four of them, and more recently, 24 CF 91 and CF 109, along with, we reviewed them on the 4th as well.
All right. And did you go over what the state would have to prove, those elements, as they apply to the facts?
Yes, Your Honor.
Or as the facts apply to the...
Let's pause here. Starkey just admitted to the charge without hesitation, and while we're all stuck on the urine-throwing partius, Grossett's actually treated under state law as an intentional act of aggression, not just a disgusting prank. The law sees this as a threat to public health and prison safety.
Did you also go over his constitutional rights and what it means by waiving his rights?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the cases with Mr. Starkey?
Yes, Your Honor.
And do you believe he's entering his pleas freely and intelligently and voluntarily here today?
Yes, Your Honor.
And do you believe he's entering his pleas competently here today?
Yes, Your Honor.
Do you have any concerns about your client entering his pleas here today?
No, Your Honor.
All right. Mr. Starkey, one last time, do you have any questions before we proceed and before I have you enter pleas today?
No, I do not. I do not have any questions.
Then as to count 1 in 24 CF 91, battery to a law enforcement officer, and H felony, how do you wish to plead?
Guilty.
As to count 1 in 24 CF 109, prisoner throwing or expelling bodily substances, and I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The remaining charges in those cases and the other 2.
Notice how methodical the judge is here. Every single question is designed to bulletproof this guilty plea. Why? Because if Starkey later claims he didn't understand or felt pressured, the court can point to this exact moment. It's all about eliminating any room for appeal.
And read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone in case questions arise. The court is again revoking bond. We have set sentencing, and that will remain on the calendar as already previously set. Anything else we need to address here today, Mr. Schmidt?
No.
Mr. Keene?
No, Your Honor.
All right. Then he may be sent back to Polk County so he can face his revocation there and whatever's going to happen there. And then once we determine what's going to happen there, we'll figure out sentencing and how that'll come into play. All right? All right.
Okay, here's where people get confused. Dismissed and read in doesn't mean he's off the hook. Think of it as ghost charges. They disappear from the conviction sheet but still haunt sentencing. Judges take them very seriously.
We will go on the record in the matters 24 CF 91, 24 CF 109, State of Wisconsin versus Justin Starkey. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starkey appearing in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of these cases. Mr. Starkey pled guilty on March 7th, 2025 to two felony counts, one battery or threat to a law enforcement officer, and one count of, I believe it was prisoner throwing or expelling bodily substances, an I felony. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. And in my review, even though I don't have as much detailed information as the counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case, and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starkey didn't have an attorney. I didn't see when they pushed it out to.
All right.
Yeah, I can answer that. Scheduled for the 6th, and I work with the public defender. They appointed me, but I hadn't got the appointment, so I'll be representing him in that as well.
Okay. Excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, Your Honor.
How many?
One.
Just one? Mr. Keene, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay. And did you go over that report with Mr. Starkey?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but I went over the main points and the recommendations.
All right. And so you went over the bulk of the main information to ensure that he can review if there are any errors?
Yes, Your Honor.
Okay. We will begin with the victim impact statement. The victim may come forward, have a seat at the black bench. Victim may state their name if they wish, or simply the initials. Yes. And if you are going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Erlenmeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently a 911 dispatcher for Burnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Burnett County, it was my job to keep inmates safe, secure, and hopefully healthy. When Justin Starkey was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I, at the time, went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall, and I fell to the cement floor. It's the last thing I ever expected from an inmate that was playing in my mind.
This testimony hits like a freight train. The victim was doing her job trying to help and ended up slammed into a wall. This wasn't some scuffle gone wrong. This was trauma. And when she says her life changed forever, you feel every word.
Possibly my partner in the cell. As a result of that action that day, my life has changed drastically. There's things I can no longer do. Correction officer is one of them. As my surgeon is concerned that it could happen again. Maybe yes, maybe no, but after 15 months, the doctors tell me I'm as healed as I'm gonna be. Which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starkey, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to.
I know. That's all I'm going to say. That's all I'm going to say about that. Okay. I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do, and that is to help the community and save the community when we can.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Sure. I'm going to be arguing for what the PSI recommends, which is 2 years initial confinement. Let me just make sure I say it accurate. 2 years initial confinement, 3 years extended supervision on the battery, and 1 year jail consecutive to it on the other count. So effectively, the 1 year jail gets converted into a prison sentence by way of Wisconsin statute. Mr. Starkey has 338 days credit per the jail. This is a 35-year-old man with a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets disability, that's been confirmed, and at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starkey in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not reactive or in direct response to a frustrating stimulus, such as how people might react if they have a traumatic brain injury and fly off the handle. In 24 CF 91, Justin Starkey was apparently having a seizure when COs went in to address it. You heard an account from the victim in that jail already. As soon as COs were in range, Mr. Starkey shot up and assaulted them, in particular, the full force kick of JL that caused life-altering injuries. This happened March 29th, 2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starkey was in both before this incident and after. And what the PSI writer discovered was that for over a year before this, and sometimes afterwards, Mr. Starkey has been in other county jails, and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starkey's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starkey to stop applying cleaning solution to the mirrors in the cells that they used to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starkey. He was just casually standing there talking. And then eventually Starkey got mad, assumed a charging posture, and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starkey or approaching Mr. Starkey when he was attacked. 24 CF 109, Mr.
Here's a gut punch of a detail. 4 probations, 4 revocations. That's a pattern the court won't overlook. And while the defense might lean on his brain injury, the judge is looking at choices consistent violent ones. What would you do if you were the judge right now?
Of his toilet and used a Kool-Aid pack, like the powder solution, to put it on it so it would soak it up to make it clumpable so you could pick it up and it would be throwable, and threw it at a deputy, a correctional officer, I should say. Again, showing deliberation and planning and really an intent to humiliate, I would say. I specifically went through the facts in these jail cases because they show something you don't really see in some of his other cases, this planning deliberative element. Mr. Starkey is intentionally using, not just in these cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs, this has been something he's been doing an extremely long period of time. It's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starkey talked to the PSI writer about the correctional officer cases versus the case with his mother. The Eau Claire conviction mentioned in there is the one where he assaulted his mother in his home. So that's different than the CO ones. That was a public assault, more akin to the first Burnett County case, the DC in public. And those two cases are more of the getting frustrated and attacking somebody cases. The way he talks about the case with his mother, it's because it's his mother, he says he's sorry. He says something to the PSI writer that when he's asked about whether he feels bad or sorry about what happened, he says just about his mother. He, even at the point when he was talking to the PSI writer, wasn't empathizing with any of these COs, not just the victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO was coming in with the medical cart with the medicine that he needed and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because 2 of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative. He can't be treated in the community. That's indicative he needs a higher level of confinement, and that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire and better establish a protocol where Mr. Starkey cannot harm officers, correctional officers. So that brings us to McCleary. Gravity of offense, protection of the public, rehabilitative needs of the offender. The gravity of the offense is severe because of the maliciousness of what's happening here, and because of the pattern that can be traced back into 2023 and also forward a bit as well, of really just wanting to attack these jailers. If you look at what is the intent, what is the impetus of why he's doing this, it's not, these are not contacts where the COs are initiating contact with him. He's initiating contact with them by faking medical issues or deliberately doing something he's told not to do. He's seeking provocation. He's seeking physical contact. And as a result, he's harming COs. He's humiliating them. He's caused an injury to one CO that has prevented her from being a CO. That Mr. Starkey has robbed from the county somebody who's extremely talented